Okay, big day. Most of Baldoni's amended complaint has been dismissed with prejudice. There are a couple of claims that are left where Wayfair can try again, but the vast majority of the amended complaint by Baldoni and Wayfair and folks against Lively and folks has been dismissed by the judge. You are hearing correctly. So I'm going to do this in a couple of parts. I have just read the legal part of it, the argument part of it, so I can understand the legal reasons. I did not read the facts. I sort of skimmed through them. So I'm going to do this in 3 parts. I'm going to explain the ruling. Then I will figure out, whether I think this is a good ruling or a bad ruling. And then I will go back and talk about sort of what's left in the case. I think that's the order I'm going to do it in. I do want to say at the outset a couple of things. 1, this ruling has absolutely zero to do with Blake Lively's original claims against Justin Baldoni, the original complaint. This has nothing to do with that. This is totally on Baldoni's claim back against her. They are essentially 2 separate cases, even though they have been consolidated together for logistics purposes. So Blake Lively So the major headline is, he does not find that there was any basis for civil extortion because no money was involved. And he does not find that Wayfair has adequately pled malice when it comes to all of the defamation claims. That's sort of the big picture. He starts by saying, here's the reason why I just don't think they can claim civil extortion for something like this. He then goes on to say, here's why the defamation claims can't go forward. And then all of the other claims kind of fall underneath those because they're all based on the same ideas. So the big headlines are no extortion, no defamation, and then everything else kind of crumbles. So something I was wrong about. I thought for sure he would grant the motion to strike that Exhibit A to the complaint because everybody asked for it. And what he did was to say, I'm not going to strike it because basically that's just pouring salt in the wound. I'm dismissing the case. What do I have to strike it for? And also I'm not going to consider it in this motion anyway. So, we knew he wasn't going to look at it. He was going to look at the complaint itself on a motion to dismiss because that's what the rule says. So he didn't actively strike it. And the way he kind of said it was that would just be kicking them when they're down. I'm dismissing their whole complaint. So I'm not going to also strike their exhibit. But he did not consider it when he looked at and ruled on the motion to dismiss. Now the things I was right about, because I got to get those out of the way. He said in a footnote, Nice Pool is not the subject of a defamation claim because it is opinion. I said. He said that you cannot use Baldoni's past statements of things he said about his corn addiction or his bad behavior or whatever against him on the motions to dismiss, which Reynolds tried to do. He said, I can't consider that. That's outside the complaint, which is what I said. He also said, I see that amicus briefs have been filed. That's very nice. I didn't read them. I didn't consider them, which is also what I said. Clearly, by the time these amicus briefs were getting filed, he was already drafting this. This has taken a long time. This is why it took so long, because they have gone through, and this probably took months to write. So I was happily right about that. He also specifically said, and we're going to hear about this a lot in the coming weeks, the court has not ruled on whether the 47.1 privilege applies. He did not get to it because he didn't need to. He said, I know that there's the litigation privilege and I know that there's the fair report privilege and I know that this privilege exists, but I didn't have to get to that one because the others did all of the work. And by the time I got done with the litigation privilege and the fair report privilege, I was dismissing the complaint anyway. So I'm sure we're going to hear a bunch of lies about how, the judge found the violation. He did not. And he specifically said that he did not. He sidestepped it because he doesn't want to be the first like I said, and in this particular case, he didn't need it. Oh, last thing is, about these allegations about group pleading and you can't tell what's against what, and like that's a basis for some big dismissal because their complaint isn't clear. He said, yeah, I realize it's not a model of clarity, but like it puts people on notice of what their suits are. So the dismissal isn't based on that either. The dismissal is not based on, this is a messy complaint. Okay, so on the merits. First of all, most of the claims, he had to do that choice of law analysis first. And in most of the claims, he chose California because the parties had agreed to that. He did choose New York law for the New York Times because he said this emanates from New York. The New York Times is based in New York. They filmed the movie in New York, whatever. The argument against that by Wayfarer was, but the damages were felt in New York. And he's like, no, I don't think there was ever really a chance he was not going to choose New York law for the New York Times. And he pretty much dealt with the New York Times the way that we thought he might, which is they get the fair report privilege. They were just reporting what they were told. It's not their fault what they're told. They just report on what somebody tells them. So civil extortion, he just said, I don't see what the damages were to Baldoni that they were holding the control of the movie over his head. I just don't, they didn't lose any money. Yeah, they were threatened, but they didn't allege the threat actually did anything to them. They just alleged the threat happened. And frankly, they haven't alleged that was some violation of law and not just like really hardcore negotiation. So, he said there weren't really facts. And even if there were, he said, there's only one case in California that talks about extortion as a civil matter. And it was a trial court case and nobody's ever cited that case. Like it's not ever caught on. There's only that one case. And he was basically like, I'm not going there. I'm not going to be the one to make that a new claim, especially when I don't have the allegations that I need. So civil extortion falls apart. And the conspiracy claims are based on, there has to be an underlying claim, an underlying tort, a conspiracy to extort, a conspiracy to commit defamation. So when he's crossing off the extortion claim, he's also crossing off every other claim that goes with it. So on the defamation, it takes many, many pages for him to say, there's no malice. There's no evidence of malice. That was really the sticking point. Baldoni's a public figure. You have to allege actual malice. And he said, there's just no allegation that any of these people, Lively, Sloan, or Reynolds, said anything outside of what was already in the CRD complaint, or if they did, had any reason to believe it wasn't absolutely true. He does say there is a powerful inference that the New York Times had the CRD complaint months before it was filed, right? And that was sort of what the defamation claim and a lot of this stuff against the New York Times was based on. But he accepted the argument that Lively made that was like, it's this bridge argument, right? That's like, there's a privilege to file a lawsuit and there's a privilege to report on a lawsuit. How can there not be a privilege in between talking to the reporter about the lawsuit you filed, right? So I think that kind of makes sense. I'm going to let it sit, but that strikes me as being pretty right. And then he went through a couple of the other things like about the text messages. Oh, we talked about the emoji. I might have to do that later, explain that more to people. There just wasn't any malice. There just wasn't any reason to believe that Sloan and Reynolds, who were getting all of their information from Lively directly because they weren't on the set, they weren't there, believed everything that they were saying. Now, he is given leave to amend on two claims, the tortious interference with contract, which is the WME stuff, and the breach of implied contract for Lively with her employment contract, which is fascinating because we haven't seen either one of those. And what he basically says is, I don't know if those claims can be repled because we don't have the fucking contracts. So Wayfarer, you can try again. And now it's really the rubber's gonna hit the road. Do we attach Lively's employment contract? Was there one? What's the contract look like with WME? So we'll see if they can allege those or if they even want to. They might just give up. So this is a huge win for Lively and team, no question. The judge has clearly thought, I'm not going to allow people to sue over, a good faith piece of litigation just because it gets reported by the New York Times. And I'm not going to get into creative disputes about a movie. I'm not going to do it. And so that's the decision that he's made. I know I'm going to be asked whether this is appealable. Long story short, yes. But I need to think about all the implications of that. So ask me questions and I'll try to answer them and I'll keep going.